We'll now call case number 113901, State of Kansas versus Christian Senzogen. Counsel, I may have not gotten your client's name correctly. I apologize for that. If you can help me with the pronunciation, I'll try to get it right the next time.
Of course. May it please the court, Meryl Carver-Ullman, Capital Appellate Defender on behalf of Mr. Senzogen. And Justice Lukert, if I could please have 3 minutes rebuttal.
3 minutes is granted.
Thank you, Your Honor. Just as a brief summary of the facts of this case, my client was married to the victim in this case. They decided to separate. In the course of that separation, the victim in this case got a protection from abuse order against my client, commonly called a PFA, that prohibited him basically from going near her. A few months later, my client was at the mall in Hutchinson. He was there to meet a date. He said at trial that he saw his now ex-wife, but left as soon as he could without any really significant interaction with her. His ex-wife and her friend that she was with had a bit different story. They said that he pulled his car in behind them and prevented them from leaving, and that he grabbed her arms and asked her to tell him that she loved him before giving up and driving away. Based on the jury obviously believed the ex-wife's version of the story, and my client was convicted of violation of a PFA and stalking based on violation of a PFA. And as the court is aware, KSA 215109 says that a defendant may be charged of either the crime charged or a lesser included offense, but not both. So we're here today on what is a pretty technical legal question of whether violation of a PFA is a lesser included offense of violation of a PFA based on stalking.
Counselor, are we talking about a PFA or a protection from stalking? And does it make any difference on which one we're talking about? I was thinking that they were different orders, but maybe not.
In this case, it was the same order, if that helps answer the question. I mean, there weren't two separate orders. It was all one order that the state was alleging was the subject of both crimes. And I want to start today by talking about, there are two subsections of 215109B. I want to start by talking about subsection 1, which is the lesser degree of the same crime subsection. As the court is aware, under that subsection, the crimes don't have to have identical elements. It's more like homicide, where you have first-degree murder, second-degree murder, and so forth. But there are differing intents and differing elements of the crimes, but we've recognized that there's still greater and lesser degrees of the same crime. Here, if you look prior to the recodification, Killingsworth was the only case that I could find that discussed this issue. And in that case, the Court of Appeals said that they were greater, lesser offenses, because they both required intentional conduct and violation of a PFA. Here, after recodification, we still have the same act, which is that violation of a PFA. The intent is different, admittedly, but here my argument, which I think I made in a 609 letter that I filed end of March, is that recklessness actually encompasses more conduct in this instance. Here we're saying that for just a regular violation of a protection from abuse order, just a technical violation, it has to be knowing. You have to do it kind of on purpose, and that's a misdemeanor. But if you cause fear, we don't care, even if it's just reckless, we're going to call that a felony because you've caused fear. There's that greater element there. And I think I've cited some cases. Edwards, we have the example of theft being a lesser included of robbery, even though robbery is a general intent crime and theft was a specific intent crime. I think Edwards was kind of the best case I had on that. In the briefing, there's some mention of other crimes that kind of fit this paradigm, and I think the briefs mention homicide, assault, and battery. But if you actually look at the battery statute, you can end up in this situation, kind of piecing, because there are about, I think, 10 forms of battery. But specifically, the easiest one I can see is if you look at A1, which requires knowingly or recklessly causing bodily harm to another person. That's a B misdemeanor. And if you look at B2A, recklessly causing great bodily harm to another person is a level 5 felony. So you could end up in that same situation where the knowing crime is the misdemeanor and the reckless crime is the felony. Gosh, looking at that argument, basically Ramirez says you look at the gravamen of the offense, and here, as they said in Killingsworth, I'm arguing that it's the same conduct here. The intent is different, but I think we've discussed that. And if you go back and look at common law, which is another thing that Ramirez says you look at, these really aren't common law crimes. That's not really applicable. So I guess that's my argument on the first subsection of the statute.
And is that important? I mean, it seems like most of the other areas where we do look at battery, assault, homicide, they are common law crimes, where we kind of have that common law history that tells us they have been historically treated that way and considered that way. Mm-hmm. And where we have the legislature creating the crimes, does that make a difference in our analysis of whether they fall under this subsection?
I don't know. I guess, the legislature created these crimes and they were considered lesser graders, at least according to that one case, prior to recodification. And if you look at the recodification report, actually it kind of indicates that where there were 2 intents, which I think stalking had 2 before the recodification committee just sort of picked one. I don't know that the legislative history and the common law history don't count here. It's just there's not much of it. So I think you really do have to put the bulk of the argument on the gravamen of the offense part here. And frankly, and I think I probably said it out better in my 609 letter than I'm saying it today, I think it just makes sense looking at the statutes as a whole together that we would want to punish reckless conduct where fear was caused, that the legislature wanted to encompass more when the victim was actually placed in fear. Moving on to subsection B2, I think that's a little bit harder argument for me, because I think you end up in a place where, and I know the court asked specifically for a briefing on the mental culpability statute and how it impacts this case. And I think it gets hard because you end up in a place where we're arguing not that the greater intent proves the lesser, but that the lesser intent proves the greater. And that's kind of introduces a whole host of probably due process problems. I think you could say, I heard, I think last month at argument, Justice Johnson and Justice Stegall were both talking about the legal fiction here created when you're saying if you prove one, you've proved the other. And I guess about the best thing I can think of under B2 is that if you've proved knowing, you've proved reckless. And so those are kind of, it still doesn't really work under the statute because it's not, the lesser crime doesn't have all of the elements of the greater. So I guess I don't want to say I'm waiving that argument, but I just don't think it's as strong as the argument under B1 is. With that, I think that pretty much concludes what I had to say.
Are there questions? Thank you, counsel.
Thank you.
Ms. Rodabaugh?
May it please the court? I'm Kimberly Rodabaugh, Senior Assistant District Attorney with Reno County, and I would respectfully request the court to uphold the Court of Appeals decision. And the points that were made in the Court of Appeals decision I don't think are complicated. And I think even the former argument or prior argument concedes the fact that what we look at are the elements of the offense. And the Court of Appeals found that in order for stalking to be proven, it requires proof of recklessness, but violation of protective order requires it to be knowingly. And the case law, although it's not specific regarding reckless and knowing on stalking and violation of protective order, says we look at the elements, we strictly construe the elements, and just because you have proved something recklessly does not necessarily mean that you have proven it knowingly. Counsel said that it used to be, prior to codification, that the elements were the same, but I think it's important to note that that's what used to be. And if you look at the legislative history, when they recodified the statute of stalking, it used to be that stalking was intentional, malicious, and repeated following or harassment of another person and making credible threats with the intent to place such person in reasonable fear for the person's safety. And that statute was repealed. 213438 was repealed in 2010. The new statute that we're looking at took effect July 1st, 2011. And there's only one mental state. It's not in the alternative. It says, recklessly engaging in a course of conduct targeted at a specific person, which would cause a reasonable person in the circumstances of the targeted person to fear for such person's safety, or the safety of a member of the person's immediate family, and the targeted person is actually placed in such fear. And the court knows through the briefing that Mr. Senzigan was convicted of both stalking and violation of protective order. Just as you asked earlier if there was a difference in the mental states between violation of protective order and violation of an order, protective order on stalking, and both of them require knowing. But as far as my knowledge and looking at that, knowingly violating a protective order, but the state would contend that the elements for stalking, number one, differ as far as the mental state required, but number two, they involve separate elements as well. In order for someone to be found guilty beyond a reasonable doubt of stalking, there has to be protection from stalking that was in effect, but then the act would be a reckless act of threatening the target's safety, reckless. In this case, he was found guilty of recklessly threatening HG's safety, recklessly confronting HG, and recklessly appearing in close proximity. The independent or additional elements were that this reckless act would cause a reasonable person to fear for their safety, and the state was able to prove beyond a reasonable doubt that HG was placed in fear, and we would contend those are separate elements. It's not a lesser offense to prove that someone knowingly violated a stalking order, and the case law that is relied upon arguing the same. Aggravated battery and battery don't necessarily merge. It depends on how the case is charged. If one of them was charged, like the aggravated battery was charged with intentionally committing an act whereby great bodily harm could occur, and the lesser would be reckless, it wouldn't necessarily merge. You have to look at how it's charged. And in this case, the two offenses were charged have primarily different elements to each offense. This court had asked additional briefing on the mental state, and the state contends that that is where we should focus, because 215202 does focus on the various types of mental state that are required for someone to be guilty of a specific crime. And 5202B says that crimes can be categorized as intentional crimes or knowing crimes or reckless crimes. And we would contend that there is a difference between the three. And as I mentioned before, stalking requires a reckless criminal mindset, and violation of protective order requires a knowing mindset. I think it's interesting in the Court of Appeals decision, I thought about this a lot. Could someone recklessly violate a protective order? And or could they recklessly commit the offense of stalking? They said it would be hard pressed to think of an instance. And I think that Mr. Sinzigan, if he knew or he went to the mall but consciously disregarded the substantial and unjustifiable risks that circumstances exist, that may be an instance where it just would be reckless instead of knowing. There could be instances, and I think that we know that by all accounts, we're supposed to follow the legislative history and look at the intent, and there's a specific reason why they have reckless there as opposed to knowing. Knowingly violating the protective order, we would have to prove, and it was proven beyond a reasonable doubt, that Mr. Sinzigan was aware of the nature of this conduct and violating the protective order.
Does the provision in this statute defining the different elements that says if you prove the lesser or the greater mental state, you've proven all mental states? Does that collapse our elements and mean that we have identity of elements here?
It wouldn't, because reckless knowing is a more stringent or a higher culpable mental state. And so if it was knowing on the violation of the protective order and it was knowing for the other offense, then those two, the one would be a lesser. But just because you prove reckless for the stalking doesn't necessarily mean you have proven knowing. And that's why there's a clear delineation. So there is analysis in 215202 that says exactly what you're saying, that if you prove a higher one, then if there's something less, then it would merge in or it'd be a lesser offense. But there's no analysis, the contrary is the same. So the state would ask this court to apply the strict element test, to not read into the statute. I think that it's both sides can, well, the state argues, and I think that the appellant concedes that the mental states are different, and I think that's what it boils down to, is if you have a higher mental state on the violation of protection from stalking, it's not going to be a lesser offense to stalking, which requires the recklessness mental state. And I'd yield to any questions. Thank you.
Thank you,
Yeah,
Council. Wait, one more.
215109D deals with specific and general crimes, and you can't be, would that have any play here? Because you both deal with the general topic of stalking. And you have one's violation of an order and one's a specific instance of stalking.
I think that for the mental state, it's not enough that it's the violation of the stalking order. It's individual that he recklessly, there's examples of where he recklessly violated the stalking order.
I understand, but I think the specific general says if you have a specific statute and a general statute, you can't be convicted of both, if they both deal with the same thing. I'm just asking you if, not talking about lesser included offenses on the culpable mental state, but if that statute has any applicability here.
I would argue that because the elements are different, I know that you're asking something different from lesser included offenses, but I know that violation of protective orders is a general intent crime because it's knowingly violating the protective order. As far as stalking being a specific intent crime, the mental state is recklessly, but there have to be additional elements that someone could be in reasonable fear, and I don't want to misstate, but someone actually was in fear.
Anything further? Thank you, Counsel.
Thank you.
May it please the court. I think just in response to a couple of things that the state has said, and I know we keep kind of going back to the battery example in the briefing and here a little bit today. The point isn't that, maybe a nice prosecutor somewhere would choose not to charge battery in a way that makes them greater and lesser included offenses. The point is that they can. And you could, again, piecing together bits of the statute, but I think there are arguably several ways that you could end up charging someone twice under that statute for the same battery, essentially, if intent is the only difference that we're looking at. Also, I mean, I think it is clear here that the mental states of these two crimes are different. The question is whether, I think as Justice Lukert put it, they collapse together under the B2 argument at least. I'm still arguing that we should avoid all this mess and decide the case under B1. If the court has any more questions, I'd be happy to answer them. Otherwise, I think that concludes my remarks, and I would just ask that Mr. Sinsagen's conviction be reversed.
Any more questions? Thank you, counsel.
Thank you.
The court will take this matter under advisement.